Major breaking news out of the United States Supreme Court. The lawyers for the NRA have filed a petition for cert in the NRA versus Glass case. This used to be called the NRA versus Bondi case, dealing with whether or not young adults in the state of Florida have the right to keep and bear arms in all respects. Let's break it down when we come back. Big deal here, folks. This may be the next Supreme Court case. We'll see. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have a petition for cert that was just filed by the National Rifle Association, the NRA, in a case called NRA versus Glass. You probably know the name of this case as NRA versus Bondi. They swapped out the name because of who is the sort of the attorney, who exactly is the official down there running law enforcement in Florida. So now the case is NRA versus Glass instead of NRA versus Bondi. And the question is whether or not Florida's law that prohibits 18, 19, and 20-year-old young adult Americans from being able to acquire firearms, purchase firearms, whether or not that's constitutional under the Second Amendment. Now, the big argument here by the NRA is that there's a clear circuit split, right? The Supreme Court doesn't just randomly take cases. They do not view their role in the system as a court that reviews errors, meaning if the courts of appeals screw up, as a general matter, the Supreme Court's not going to get involved because they don't have the bandwidth to general matter. Now, you can debate whether or not that's a good or bad idea, but that is the reality on the ground. The Supreme Court only wants to take cases that can set precedent, that have a long, multi-decade ripple effect, and address some major issue of law where there's confusion in the lower courts. Well, that is certainly the case here when it comes to the question of whether or not the Second Amendment protects the full-blown right to keep and bear arms of 18, 19, and 20-year-olds, because, again, Florida has a law that was enacted after Parkland, after the Parkland school shooting, which, of course, as you know from the Parkland report, the advice, side note, was we should arm the teachers and administrators because the police don't get there in time. But I digress. Anyway, after the Parkland school shooting, the state of Florida's legislature passed a law that says 18, 19, and 20-year-olds cannot purchase guns, and that was challenged. And basically that law so far has been upheld, including, surprisingly, frankly, by the United States Court of Appeals for the 11th Circuit down there, with a decision by a former NRA award-winning attorney by the name of William Pryor. Judge William Pryor was in the majority. He totally screwed this up. I like Judge Pryor. Good guy. But this one, nope, went off the rails. This is going to get reversed, is my suspect, and he is going to be told, no, you did this wrong. Too bad, but people make mistakes. Even good people that try hard can screw things up. Happens all the time, and I think this is an example where Judge Pryor did exactly that in this decision, where he found that Florida's law was consistent with the text and the history of the Second Amendment. I think that is clearly the wrong answer. So the question becomes, why should the U.S. Supreme Court grant cert in this case, given the fact that just a month ago, the U.S. Supreme Court denied cert in a very similar case, in the Worth case? You may recall the U.S. Court of Appeals for the 8th Circuit that arises out of places like Missouri and Minnesota, that part of the country, the Midwest. The 8th Circuit had ruled that 18, 19, and 20-year-olds have full-blown Second Amendment rights, and thus they had a right to carry guns in the state of Minnesota under the state's concealed carry law. The state of Minnesota sought cert in that case, and the U.S. Supreme Court denied cert in the Worth case, which was, again, a big win for the Second Amendment, because that means that all the 18, 19, and 20-year-olds that live within the 8th Circuit now get to carry guns. They have a full-blown right to carry guns, and that's a great thing. Now, let's carry on. So here you have, in the Glass case out of the 11th Circuit, you now have what's known as a circuit split, And what is a circuit split? It's quite simple. We have about 13 circuits around the country, and when the circuit split on what the right answer is to a legal question, in this case, does the Second Amendment apply fully to 18, 19, and 20-year-old adults, or are they basically viewed as children for the purposes of the fundamental right to keep and bear arms? There is now a circuit split. The 8th Circuit in the Worth case, I believe the 3rd Circuit in the Lohr case said that 18, 19, and 20-year-olds have the right to keep and bear arms just like anybody else that's a full-blown adult. And then now you have the 10th Circuit and the 11th Circuit are saying just the opposite. That the Second Amendment, based on the historical tradition of firearms regulation, allows states to prevent 18, 19, and 20-year-olds from being able to have guns, being able to exercise their Second Amendment rights under the Bruin methodology. So you now have that conflict there among the circuits. Beyond that, the argument by the NRA also says that this decision by Judge Pryor and the majority in this en banc decision, just as a reminder, the 11th Circuit decision in the Bondi case, which is now the NRA versus Glass case, this was a split decision based on an en banc panel, meaning all the active judges in the 11th Circuit sat and heard this case, and the majority came out saying that that this law of Florida's is constitutional. And I think that's clearly wrong. So let's just turn to see some of the arguments that were made by the NRA. I think there's some quite good stuff here. And they cite to an extremely handsome YouTuber on page 26. We'll get to that in just one moment. But to begin with, this is the point they're making as to why the Supreme Court should grant cert in this case. And just for those of you out there who don't know what that means, the Supreme Court has no obligation to hear your case or any case as a general matter. And as a consequence, you have to ask them to hear your case. The way you ask the Supreme Court to hear your case and decide your case is you file a petition for cert in the U.S. Supreme Court, asking them to grant that petition, and then they will hear the case with full-blown briefing and oral argument, and then a decision, and so on and so on. And that is what the NRA is doing here. They're petitioning the Supreme Court for cert, and now we have to see in the next month or two, what will the U.S. Supreme Court do? So anyway, let's start off with what their first argument is by the NRA to the Supreme Court just now. The right to keep and bear arms belongs to all Americans, not an unspecified subset. Yet the federal courts of appeals are divided over the extent to which the government may prevent 18 to 20-year-old adults from exercising that right, including over whether it may bar them from purchasing the firearms they wish to keep and bear. In nearly every state in the Union, including Florida, 18-year-olds are legal adults. They are entitled to vote, marry, enter contracts, and join the military to fight and die for their country. And as adults, there are no parents or other legal guardians generally responsible for their care and protection. In the jurisdictions within the Fifth Circuit Court of Appeals down there in Texas and Louisiana, they also enjoy the Second Amendment right to purchase firearms to defend themselves and their families. But under the 11th Circuit's ruling here, and a similar ruling by the 10th Circuit, states in those jurisdictions can and do bar these legal adults as a class from purchasing any firearms. This split between the circuits over the fundamental question is intolerable, and it urgently calls for the Supreme Court's resolution. Exactly right. It's time for the Supreme Court to step up and resolve this. And I just want to tell you another sort of inside baseball thing that may be going on here. You may ask, why did the Supreme Court deny cert in the Worth case, which deals with whether or not Minnesota's law that banned the carrying of guns by 18, 19, and 20-year-olds, because I don't think they could not apply for a concealed carry permit in Minnesota if you're 18, 19, or 20, versus the Glass Bondi case here involving the NRA. What is the difference? Well, in addition to dealing with 18, 19, and 20-year-olds and whether or not they have a right to keep and bear arms, what's the other clear difference? Here's the story. The Bondi Glass case here deals with the right to purchase guns. The Worth case dealt with the right to carry them in public. So the reason why I think it is good if the Supreme Court grants cert in the Glass case here is because not only will they answer the question of 18, 19, and 20-year-olds and whether or not they have full-blown Second Amendment rights, which I think the answer should undeniably be yes, it also will allow the U.S. Supreme Court to deal with this notion of concomitant or ancillary rights within the text of the Constitution. Specifically, the word purchase or acquire obviously does not appear in the text of the Second Amendment. It says the right of the people to keep, which means to possess, and the right to bear, which means to carry arms, shall not be infringed. It doesn't say you have the right to acquire guns or purchase guns. So I think that if the Supreme Court grants cert in this case of NRA versus Glass, it will also allow the Supreme Court to address not just the young adult question, which is very important. It will also allow them to address a second equally important question when it comes to interpreting and applying the Second Amendment in fights. And that is whether or not the concomitant right to acquire and or to purchase firearms is part of the text of the Second Amendment. And I think the answer is undeniably going to be yes. So if the Supreme Court grants cert in the NRA versus Glass case, I think this will be very good for us. I think that not only will 18, 19, and 20-year-olds win the day and have their full-blown rights, that's my prediction, but also it would allow the Supreme Court to make clear that there's certain ancillary or concomitant rights implicit within the text of the Second Amendment, including the right to acquire, the right to purchase firearms. And that will be very helpful because there's a lot of anti-gun judges out there and anti-gun courts that play games and say that there is no right to acquire, there is no right to purchase firearms as under the text of the Second Amendment. And they play all sorts of games to basically, shut down Second Amendment challenges when it comes to trying to acquire guns or buying ammo and things like that, whatever. But you get the idea. So that would be a second important reason why the Supreme Court should take this case in terms of being able to resolve two Second Amendment related issues. And of course, by taking this case and reaffirming the Bruin methodology, that's also good because we want to make sure that the Bruin methodology of text first, burden shifting to the government, and historical analysis is reaffirmed and reaffirmed and reaffirmed because we don't want the anti-gun efforts to sneak back into the methodology, some sort of interest balancing, which is what the anti-gunners want desperately because they want all their lower court judges to be able to weigh the good and the bad of guns, which is not appropriate because the good and the bad of guns has already been weighed by we the people in the form of the Second Amendment itself. And that's something that's often lost in the debate here, that we the people were adopting the Constitution, adopted the Second Amendment. Therefore, it is based on democracy. It's based on we the people. It's based on the Republican form of government, right? Because the Second Amendment didn't come from outer space or anything. It was debated and approved by we the people when the American people adopted and approved of the Bill of Rights as part of our Constitution. So never forget that fact. So to allow judges to interest balance away, which is just a euphemism for saying, yeah, we think that this federal law or the state law violates the Second Amendment, but when we balance it all out, think that the government has a good enough reason, a compelling reason to allow this infringement on our rights, and therefore it's okie dokie. Yeah, terrible idea. I know a lot of people out there, even very smart people, argue for tiers of scrutiny, and in some fantasy utopian land, that might make sense. But in the real world where judges don't like guns as a general matter, don't understand guns, don't know the difference between semi-automatic rifles and automatic rifles or any of this stuff, and are easily duped, the last thing we want are these judges out there weighing whether or not the government has a good enough reason to take away our rights. That is a bad plan in my view, and the Supreme Court, I'm happy to say, has agreed with Mark Smith in the Four Boxes Diner repeatedly, and we don't want that trend to change. So again, every single time the Supreme Court applies the Bruin methodology of text first and history second, this is a good thing because it makes it less and less likely that the Supreme Court down the road will embrace a different theory, incorporating into their Second Amendment jurisprudence some sort of interest balancing, cost-benefit analysis, or anything like this. We definitely don't want a bunch of public health school professionals in some school funded by Michael Bloomberg out there, setting forth thousands and thousands of pages of studies that guns are bad. In addition to that being wrong, the fact is you don't want to have to litigate that, nor should you have to litigate that in courts. And that's why it's very important that we have the Supreme Court reaffirm the Bruin methodology as often as we can. The last thing I want to mention before I wrap up is the NRA on page 26 of this brief, which I'll put a link to it in the description of this video below. On page 26, they do talk on cite to Mark Smith here. This is what they have to say to the United States Supreme Court in their brief seeking cert. For decades, the Supreme Court has generally assumed that the public understanding of the right when the Bill of Rights was adopted in 1791 governs in cases involving federal law. And the court has made emphatically clear that once a Bill of Rights protection is incorporated, there is no daylight between the federal and state conduct it prohibits or requires. It follows that 1791 is the focal point for inquiry into the Second Amendment's historically understood limits. See Mark W. Smith. Attention originalists, the Second Amendment was adopted in 1791, not 1868. Harvard Journal of Law and Public Policy in December of 2022. All right, folks, so there you have it. So let's see what happens with the Supreme Court if they take this case. In a perfect world, I think they take the NRA versus Glass case, and I think they take the Snope case. I certainly would not object if they took the Wolford case, which deals with sensitive places and that so-called vampire rule or default rule. I think that's also, if the Supreme Court's really interested in trying to clear up some of the Second Amendment stuff, they would take 3 of these cases. They would clear up the young adults. They would clear up the AR-15 ban issue, which if they grant cert in that case, we're going to win that one. That's what's irritating to me, that if they take a semi-automatic rifle case, I don't see how we lose that case. I really don't. But we need them to get off their dupas and take that Snope case or something like that to resolve it. But if they take the young adult case, the AR-15 ban case, and, of course, the Wolford case, which I think is a relatively easy win for the Second Amendment, dealing with the default provision or vampire rule. I think that's a pretty easy way to win a sensitive places case. Knocks out one of the sort of novel arguments that the liberals are making about you can't bring a gun into a grocery store or a convenience store or a gas station or anywhere without first getting explicit permission from the owner to walk in there with your gun. It doesn't work that way with any other constitutional right. I don't think it'll work here. But again, I don't know if the Supreme Court is interested enough in the Second Amendment to take multiple 2A cases in a term. My guess is they're probably not. They're much more interested in religious liberties, which is fine. But I think that it'd be nice if they did more Second Amendment work. And maybe they will. Maybe they will. We'll see what happens. I don't think it's impossible. They know the Second Amendment's important. There's going to be a lot of pressure on the Supreme Court by the Trump administration is my guess. I suspect the Solicitor General may weigh in on this case, urging the Supreme Court to take more of these Second Amendment cases. And that is a very good thing because, as I explained to you before, the Trump administration's 2A thing was really going to get cranking in a very good way once we got John Sauer confirmed as the Solicitor General, once we got Harmeet Dillon confirmed as the head of the Civil Rights Division over there at DOJ. They're both in there cranking away. And I think we're going to see a lot more activity in our favor in the U.S. Supreme Court on behalf of the United States Department of Justice under Donald Trump and Pam Bondi. I'm pretty confident of that. But again, the history of the future has yet to be written. So there you have it. Okay, folks, hope you enjoyed today's episode. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe both to YouTube and Rumble. And I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.